In this lesson, we are going to consider the organization of courts in the UK. Now, as we considered in the previous lesson, the UK's court structure is hierarchical, as in you have a court of first instance or an original court and several appellate courts above that. It's interesting to note that there is an inverse relationship between the importance of case law that are taken up by these courts of law and the volume of cases that are in fact brought before court itself. So this particular graph actually notes that in terms of importance, the Supreme Court of the UK, which is the highest jurisdiction or the highest appellate court within the country, actually has a very limited number of cases in terms of volume, but the importance of those cases is great. As we noted earlier, appellate courts deals with matters of law and not that of facts. Whereas conversely, in terms of magistrates courts, the volume of case law is greater, yet the importance in relation to appellate courts is somewhat lesser. The first court that we'll consider is the Magistrates Court, or a first instance original court. The jurisdiction that a Magistrates Court has is for minor criminal matters, for instance, petty theft, traffic offences. It's not entitled, or it does not have the jurisdiction to hear serious offences such as murder. However, there are instances where preliminary hearings are made for such serious offences in order to see if there's a prima facie case to be heard, whether there are enough facts or enough evidence for a case to start proper. Next up, we'll consider the county court. Now, initially, following the Magistrates Court, the immediate appellate jurisdiction was with the High Court. However, it was burdensome for the High Court to take in the excessive volume from the Magistrates Court itself. Therefore, the County Court came about as a stopgap measure, something that will ease the burden off of the High Court in terms of small matters. So in terms of the jurisdiction and the types of cases that a County Court hears, they are much like Magistrates Courts, minor civil cases. It's an original court of law, contractual cases which are less than £25,000, and geographically it's limited by its location, by where exactly this particular county court is. Conversely, this next court, which is the Crown Court, has no geographical limitation, and it sits in a variety of places. Now, this is the first instance that we see a connection between two courts of law. As in, we considered earlier the Magistrates Court having to actually see if there's a prima facie case in terms of a serious offence. These cases which the magistrates consider to have in fact a case to be heard is in fact forwarded to the Crown Court. Next up, one of the most important courts of law in terms of this original jurisdiction that we were considering in terms of the Magistrates Court as well as the Crown Court is the High Court. And in terms of the volume of cases as well as the types that come about to the High Court, there is in fact three divisions. Firstly, there is the Queen's Bench division, which considers cases which do not go to the County Court in the context of contracts or torts, mostly civil matters. Secondly, there is the Family Division, which, as the name itself implies, deals with matters concerning children and families. Finally, there's the Chancery Division, which pertains to matters concerning equitable principle. Now, mind you, these divisions are not set in stone. It is merely for administrative purposes that they have been divided in this way. Now, it's notable that if an individual wishes to challenge an administrative decision by the executive, then he or she should actually bring it to the Queen's Bench division of the High Court. The two top-tier appellate jurisdictions are enjoyed by the Court of Appeal and the Supreme Court, and therefore we will take a quick summary of the two of them together. The Court of Appeal divides itself into the Criminal Division and the Civil Division. The Criminal Division is headed by the Lord Chief Justice, and the Civil Division is headed by the Master of the Rolls. This is an exclusively appellate court, similar to the Supreme Court as well, which was established by the Supreme Court Act of 2009. Finally, two other courts of law that we must discuss is firstly the Privy Council, which is in fact a body established to advise the monarch on sovereign matters outside of the UK initially. It was the highest court of law, even for foreign colonies of the UK or jurisdictions outside that of the UK. The ECJ or the European Court of Justice, has no jurisdiction within the English legal system. But following the accession of the UK to the European Union, it is important to the English legal system. As in, the ECJ, or the European Court of Justice, is called upon to provide interpretations on treaty agreements by the domestic courts itself. That was a brief outline of the various types of courts which are in effect within the UK.